Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on the levy of penalty under section 271 subsection 1 clause C on the assessee for furnishing inaccurate particulars or for concealment of income. The issue before the Honorable Bombay High Court in the present case was that if some addition has been made on the assessee on the basis of some estimation and the assessee has accepted the addition, so whether the acceptance of addition by the assessee su moto give the power to the assessing officer to levy the penalty on the assessee, or in other words whether the same material which has been relied on by the assessing officer in making the addition can be relied for imposing the penalty on the assessee. This issue has been taken up by Honorable Bombay High Court in the case of Principal Commissioner of Income Tax versus Color Private Limited. This case is reported in 486 ITR at page number 300 and the date of the judgment is 16th September 2025. In the present case, the assessment against the assessee was completed under section 147 read with section 143 subsection 3. During the assessment proceedings, there were allegations on the assessee that assessee has made some fictitious or bogus purchases. The assessee in the assessment has produced mountain of the evidences in the form of purchase bills, invoices, purchase orders, delivery challans, bank statement and stock records, etc. The assessing officer consciously accepted the purchases of the assessee, but at the same time on the basis of information or inquiry with the sales tax department hold that the book results of the assessee are suspicious and accordingly rejected the books of accounts of the assessee under section 145 subsection 3 and made an ad hoc addition of 12.5%. The assessee didn't challenge that addition, paid the taxes, and when the assessing officer completed this assessment and the assessee accepted the acceptance, the assessing officer levied the penalty on the assessee under section 271 subsection 1 clause C for the concealment of income. The stance of the assessee was that for the levying penalty under section 271 subsection 1 clause C, the satisfaction of the assessing officer about concealment of income or furnishing of inaccurate particulars of income is sine qua non. It was the submission of the assessee that for imposing the penalty there should be some conscious attempt on the part of the assessee to conceal the income, or there should be some deliberate attempt on the part of the assessee to furnish inaccurate particulars. But the assessing officer did not accept the submission of the assessee and levied the penalty, which was deleted by the learned CIT appeal and later on by the tribunal also. The revenue challenged the order of the tribunal before the Honorable Bombay High Court, and when the court heard the matter, the court said that in the present case the assessing officer has grossly failed to prove that the assessee has consciously concealed the particulars of income. The court said that in the present case there was no deliberate attempt by the assessee to furnish inaccurate particulars, and simply the assessee agreement to the addition did not amount to acceptance of concealment of income. The court said that the assessment and the penalty proceedings are always different and there should be some material with the assessing officer which proves that there is concealment of income or furnishing of inaccurate particulars, and moreover whenever the additions are being made on the basis of some additions on the basis of some estimation, or when the additions are on ad hoc basis, in those cases it cannot be said that the assessee has furnished inaccurate particulars or has concealed his income. So in the present case the court said that mere acceptance of the assessee of the addition does not give power to the assessing officer to levy the penalty on the assessee. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus KULKARNI Private Limited, and this case is reported in 486 ITR at page number 300, and the date of the judgment is 16th September 2025. Thank you, friends.